you hear me? Okay,
Yes.
great. Hi. My name is Sarah Tofte, and I am the Research and Implementation Director for Everytown for Gun Safety, which is the nation's largest gun violence prevention organization in the country. And it really is such an honor to be here today to talk about an issue that is incredibly important to us and incredibly important to women and children and incredibly important to community safety in communities across the country, including in Rhode Island. I come here today as an expert on gun violence prevention and as someone who has dedicated the vast majority of my career to addressing sexual and domestic violence in the United States. And more specifically, as folks have referenced earlier, I am the lead researcher on Everytown's study of Rhode Island domestic abuse protective orders as it relates to firearm relinquishment. I'm going to cover two things and then really look forward to your questions about the research. First, as you've heard before, but want to reiterate the threat that guns pose in domestic violence situations, and second, the findings of our study and the way in which those findings underscored the gaps in current Rhode Island law and the need for H 5510. So, nearly 130,000 women in Rhode Island report experiencing some form of domestic violence in their lifetime. And as you've heard, over the last 10 years, at least 54 Rhode Islanders have lost their lives in domestic violence homicides. And as you've also heard, we know study after study after study done by independent researchers, not by Everytown, not by interest groups, show that guns in the hands of domestic abusers can turn abuse into murder. It's actually one of the most direct links we see in the gun violence prevention movement. In Rhode Island, like has been mentioned, more women were killed by an intimate partner with a firearm than by any other means, and actually any bystander that was killed.
I don't think that was his testimony, though. Well, by any other means, yes,
Yep.
but not all other means combined. Okay, all right, yes.
No, thank you. Oh, feel free to interrupt me.
Right.
And all bystanders that were killed in such incidents were killed with firearms, right? So there's a huge impact there. And again, the presence of a gun in a domestic violence situation makes it 5 times more likely that the woman will be killed nationwide. So the good news is that there are ways to reduce the threat of firearms to domestic violence victims. One is to prohibit possession of firearms of those convicted of domestic violence crimes, including misdemeanors. And the other is to require that all prohibited abusers turn their guns in when they become prohibited. And the reason that we care so deeply about those policies is because, again, those are the gun violence prevention policies that have the strongest evidence behind them that they are proven to work. These laws have been studied in jurisdictions across the country, again, by independent researchers, and study after study shows that in places that have these laws in place, they see a significant reduction in intimate partner gun homicides, up to 25%. And that's when you take into consideration all other factors that are at play, right? So we just believe strongly that these laws work. And we have seen them work in practice. As in addition to being the director of research, I'm the director of the implementation program at Everytown, meaning once a strong law, a law that we think has value, is passed, we come into jurisdictions and help behind the scenes work on implementation. And we have seen strong domestic violence relinquishment programs in jurisdictions across the country, in places from Dallas to Miami, rural Colorado to Phoenix. We've seen the impact these laws can have when put into practice. So turning to the research that we did in Rhode Island specifically, about 2 years ago in 2015, we were asked by some stakeholders on the ground, some of our allies on the ground, to come in and look at what was happening, how often was relinquishment being ordered in protective orders in civil cases. And in part, we were asked to do that. The context at the time was when people were thinking...
I'm sorry, I do not mean to interrupt you, but your study was limited to civil cases?
It was limited to protective orders, final protective orders in family and district court.
Okay, well, the family court would be civil, but the district court would be criminal. And I just want to make sure I understand your testimony. You did say...
They were all civil.
They were all civil?
Yes. But there were
didn't look at criminal cases.
In which, they were all civil cases.
Okay.
Yeah. Civil protective orders, yes. Yeah.
Mr. Chairman, just
Yes, Representative Knight.
There's 3 ways to get some order that is domestic in nature. district court can issue a civil order under the same procedure the family court does, but there's also the criminal side, which is a whole other procedure.
Okay, I just had never realized that the study was limited to civil matters.
Right. Because there's no,
where the 13% number comes from.
Right, there's no affidavit in the criminal ones. Their methodology wouldn't have worked.
I'm sorry, I didn't mean to interrupt.
No problem.
I just want to make sure that we understand it.
So, as you know, protective order serves an important recourse for victims of domestic violence. And in Rhode Island, when a victim of abuse obtains a final domestic abuse protective order, in most cases, federal law prohibits that abuser from buying or possessing firearms, meaning that he or she will fail background check if he tries to buy a gun. And as you know, under current state law, while the court that issues the protective order can require the prohibited abuser to turn in his guns, it is not required to do so. Again, we were asked to look into this in part because I think our understanding of folks that were either in support of laws like this or against laws like this was that their understanding was judges are probably ordering relinquishment at a pretty high rate in Rhode Island. I think that was the perception on some level. And we were sort of asked to come in to see, what does it look like? How does it play out? And so we were very grateful. We had tremendous we were given tremendous access by the state court administrator's office and the court clerks from every family and district court in which there were final protective orders for us to view. So we were very, very grateful for that. And they gave us every protective order between 2012 through 2014 and every final protective order that was sort of publicly available for us to view. And we were able to dig in and read all those orders. And so, again, you've heard some of this throughout the evening, but again, what we found was despite their authority to do so, courts rarely ordered abusers who were subject to final domestic protective orders to turn in their firearms. I just want to note here, I know folks have talked a lot about, and sounds like there's a lot of conversations to be had about to what extent this bill, what kinds of crimes and cases it will cover. I will say in the protective order context, we found that already 75% of those protective orders were federally prohibiting, right? And so I think that's an important point to note. And again, I know there's a lot of discussion about how far beyond federal definitions you might go. But in those cases, in a sense, the die is sort of already cast for the respondent in those cases, meaning that federal law has already prohibited them. The judge has already decided federal law prohibits you from possessing firearms, right? So at that point, sort of that's where the law has decided to intervene to say, you can't own these firearms anymore. What relinquishment bills do in Rhode Island and across the country is just create a process, a clear process, both I think to put the defendant on some notice about what this prohibitor means, and also to remind them you're not allowed currently to possess these firearms, so we need to come up with a process to make sure you've complied with that prohibition by having you surrender those firearms in a particular protocol or fashion. Again, among the more than 1,600 final protective orders we reviewed, we found that courts had ordered abusers to turn in any guns they might have in just 5% of the cases. And in nearly 1 in 4 final orders, we found that there was some evidence that the abuser either had a firearm or had access to a firearm or threatened to use a firearm against the victim. And again, even in those cases, courts ordered the abuser to turn in their firearms in less than 13% of the cases. As a result, we found about 325 abusers who appeared to have some access to firearms, including many who had directly threatened their partner with a gun, who were not required to turn them in. Now, opponents of our research have sought at times to belittle the meaning of our findings by questioning the seriousness of the allegations contained in the protective order files. And as someone who has read through tens of thousands of pages of affidavits from victims in Rhode Island, I can attest to the patterns of fear, intimidation, and violence that led victims to seek protection from the courts, especially when the abuse involved the use or threatened use of a firearm. There was the woman whose estranged husband broke into the new home that she shared with their young children, and after threatening her life, told her that he was going to go back to his truck and get his gun to kill her. There was the woman whose former boyfriend made her lay on the floor of her apartment and put a gun to her head and told her he would put a bullet in her head and leave her there to die. Both women asked the court to require that their abusers surrender their firearms. In both cases, the courts did not do so.
I don't mean to interrupt again, but those were civil cases? Why weren't criminal charges filed?
Additional criminal charges may have been filed. We can talk a little bit about what we had access to in terms of the record.
So, Representative Knight, could you have a parallel case like that?
In a case where something bad happened and there's a civil...
Well, Sarah's testimony is, I mean, those are really very truly frightening fact patterns. So the question is why but her research is on civil protective orders. So my question is why wasn't there a criminal matter involved there?
Well, there's...
I hate to put you on the spot, but
no.
You've become the committee expert on it.
That's fine. There's a lot of times, there are competing processes, and they're really, one doesn't have anything to do with the other. You can get a situation in district court where somebody's charged criminally and they catch, I don't know, they catch a year of whatever because that's the limit of the district court's jurisdiction in criminal matters. And the complaining witness may want to go over to the family court where they can get 3 years of protection, right, with a real restraining order. And when I say a real restraining order, I mean one that has criminal penalties if it's violated. So there's 1,001 reasons why you might pursue two cases kind of in parallel. There's also reasons why a complaining witness may decide to forego a report to the police because he's my husband, I don't want to get him in trouble, he needs his job, I don't want to get a criminal record, but I still want the protection afforded by the family court, even on bad factual scenarios. And the cops may not necessarily be involved at all ever.
I just find it very difficult to believe a family court judge would hear that fact pattern and not issue an order to remove the guns.
Well, and
without more.
And that goes back to my earlier point that I think we're all thinking about firearms in a different context in this day and age, especially since Newtown, right? In all the mass shootings we have, I think everybody's rethinking it, and the old ways of doing things are not the way we're doing it these days.
Yeah, but this data is from 2 years ago.
Yeah, but even then, I mean, I think minds are changing.
Okay, I'm sorry, Sarah, to interrupt yet again. Please continue.
Okay. Our opponents at times have also excused the actions of those subject to protective orders by noting that they, sort of may be good guys who made an innocent mistake. So last year, one of the things we did, we went back into the sample of protective order, or the protective orders that we had, and looked at a sample of those orders just to get a sense of what the subsequent criminal histories of those abusers might be. It was sort of a huge undertaking to try to do all 1,600. It was hard to sort of go back in time a bit, so we were trying to move forward to see post-protective order, sort of what was going on with some of these individuals. Nearly 1 in 4 abusers had a subsequent run-in with the law after the issuance of a final protective order, and many of those abusers went on to commit pretty serious crimes, including crimes of felonious assault, robbery, and domestic violence. Far from being, good guys who made one mistake, we found individuals who actually posed a pretty serious threat to their communities, and we found at least, I think, 10 cases or so where they still had access to a firearm subsequent to the protective order. And one case in particular, one man shot at a woman with a .22 caliber rifle, telling her, "I got a bullet in here just for you." He was charged with assault with a firearm, but less than a year earlier, his former dating partner had taken out a final protective order against him and explicitly asked the court to make him surrender his guns, and the court did not grant that request. I know, as an expert on domestic violence, that one bill or one law will not and cannot stop all domestic violence, gun threats, injuries, and homicides. But as we learn more and more about the role firearms play in domestic violence situations, not just in terms of injuries and death, but in terms of what a role they play in terms of threats. Recent research coming out from CDC has shown that at least 4 million women in the U.S. report being threatened with a firearm in their lifetime. At the same time, 1 in 4 women who identify as domestic violence abuse victims report that a firearm played a role in the domestic abuse. So as we continue to learn more and more about firearms and the intersection with firearms and domestic violence, we understand more why laws like separating abusers from access to their firearms have such a key role to play in reducing firearm injuries and deaths of women and children across the country. H5510 would give Rhode Island law enforcement and prosecutors lawyers and judges critical tools to ensure that domestic abusers are not able to possess guns and use them to harm their victims. And this bill would really bring Rhode Island, as has been mentioned before, in line with federal law and the laws in the majority of other states. So I respectfully urge this committee to vote yes on this bill, and very grateful for the time you've taken this evening to hear from all of us.
Okay, thank you, Sarah. Any questions? Representative Price?
Thank you, Chairman. So, what organization are you with?
I'm with Everytown for gun safety.
Okay, so this is your folder, flyer. And so you're not solely dedicated to Rhode Island, you're a nationwide?
Yes, we work across the country.
You yourself are moved around the country?
I go a lot of places, yeah.
Okay, so I guess I'm just curious, because I heard earlier that Rhode Island's like either the first or second safest state as far as domestic violence goes. I'm just kind of curious as why you're focusing on Rhode Island if we're already a pretty safe state. I don't agree with domestic violence or anything. I just see an organization going around the country and going to each state and then stopping at one of the states that's already doing pretty well.
Yeah. Well, I think in part, like I said, at least 27 states already have laws like this in place, right? So we're focused on the states that don't have laws in place. And I think with Rhode Island, while it's true that you actually are sort of one of the safest states in terms of domestic violence, gun homicides, the fact is, again, state after state after state, when they enact these laws, they see reductions in firearm injuries and firearm deaths, right? So we want that for Rhode Island, too, because, again, as you heard, you do have domestic violence gun homicides, you do have domestic violence gun injuries, and guns play a significant role in domestic violence cases. So if we know that there are laws and policies in place that can reduce that threat, even if you're one of the best in the country, it can always be better. And that will mean a great deal to communities in Rhode Island.
So you did mention your stakeholders wanted you to take a look at Rhode Island?
Yeah.
How would you define, or who would your stakeholders be?
And it depends on the state who they are. We were talking with domestic violence organizations in Rhode Island. We had some conversations with some lawyers, folks that had been judges before, law enforcement officials who were more like, we think this is what the situation is, but it'd be interesting to see and learn more. And we wanted to make that commitment and could make that commitment to coming in and taking sort of the time and resources it took to dig in and learn more.
I heard earlier from one of the Second Amendment people about Bloomberg money.
Yeah.
Do you guys take money from Bloomberg?
Well, as you probably all know, we were founded by Michael Bloomberg when he was in City Hall in New York City, and folks reference that organization, Mayors Against Illegal Guns, and we became Everytown for Gun Safety when we joined up with a grassroots organization called Moms Demand Action for Gun Sense. And we take money from all kinds of donors from across the country, small donations, medium donations, large donations, Republicans, Democrats, so we have lots of donors.
So do you know of any instance in Rhode Island that if when a protective order was issued and the guns were not taken, that the gun was used in the one of the 19 gun homicides in Rhode Island?
Well, we didn't dig into and do the study on the gun homicides itself, right? And it would be interesting to dig into that a little bit more. What we did, again, and what we had access to was, again, looking at the protective orders and then trying to follow some of these individuals as best we could. We don't have direct access to the criminal justice system and the files there, but sort of looking at what we could ascertain about subsequent criminal records. And in those cases, like I said, we found at least 10 individuals who continued to have access to firearms when law enforcement stopped them or came across them. And we also had at least one incident in which someone had used the firearm he owned at the time the protective order was issued, and used it to shoot at sort of a female victim in his home. So, and again, that was just from what we could discern from sort of a smaller sample of the protective orders we looked at. And it'd be really interesting to sort of dig in a little bit more and look comprehensively to see in how many instances did someone end up sort of continuing to possess a firearm, both in violation of of the protective order itself and the prohibitor that the protective order applies, and also in a way that threatens public safety.
So is this kind of like a boilerplate type legislation that you're putting around the country?
No, not necessarily. I mean, the concept can be similar, right? Like I said, we believe very deeply that these laws work, and it's why we advocate for them, right? But every state, it's complicated. I mean, as you all have spent so many hours trying to discussing and figuring out, to what extent Rhode Island defines domestic violence differently than some other states. Some states have much more detailed protocols. If they decide to move towards surrender and relinquishment laws, the protocols have to line up with what makes most sense for the state and the state systems that are in place. So every state law looks quite a bit different. But the heart of it sort of remains the same, which is that we know there's value in prohibiting domestic abusers from possessing firearms, and then we know there's value in ensuring that once they're prohibited, that there's a process and protocol to surrender those firearms.
Thank you.
Representative Vella Wilkinson.
Thank you, Mr. Chairman. Thank you very much for your testimony this evening. I'm looking at page 2. Page 2 of your study, and it's showing that under 25% of the final orders were precipitated by petitions which contained evidence showing a firearm was present or the abuser threatened to use one against the victim.
Yeah.
So in those other 75-plus instances, what was actually used against the victim?
Oh gosh, it varied, but that's a really good question. So a lot of the protective orders have what we would call lethality risk factors. So if you set aside presence of firearm, which is a lethality risk factor, in a lot of cases we saw threats of strangulation. We saw threats of other kinds of physical abuse. We saw again, a wide range of sort of abusive behavior.
Any other types of weapons that were evident?
Threatening with a knife came up several times. Throwing objects at someone, using your hands. And I think perhaps maybe part of what we're getting at here this evening is that, yes, guns are not the only way that an abuser may use a weapon to harm a victim. I think, again, what we do know from research, though, is guns are just a much more lethal. They are the most lethal weapon of all weapons in general, right? So there's a certain inherent lethality to them when they're used against an individual. And again, I think that's why folks that work on domestic violence and work on these issues understand how essential it can be to make sure that an abuser is separated from that particular weapon, in these kinds of cases.
All right, thank you.
Representative Corvese.
I may not have heard you correctly, so please correct me if I'm wrong. The 19 domestic violence gun deaths over the 9 years you looked, which is approximately 2 each year.
Yeah.
Which is too many. Did you look into those 19 to see if there were protective order violations or anything?
This is
because I know you looked at everything else. Yeah. Well, but I'm wondering if you looked at the actual 19 to see, of those 19, were there violations of the protective order that involved a gun that was used to murder the individual?
Mm-hmm. Yeah, so I understand, we looked pretty deeply into all the circumstances that we could look into when it came to these particular protective orders. But
not the protective orders, I'm talking about the 19 deaths.
Yep, and I think that was the research that the Rhode Island Domestic Violence Coalition really led on, and so they could speak to that.
Okay.
And again, I will say, whatever is found there. Again, I will also say, and I just keep coming back to sort of the growing body of evidence that shows that, again, these laws will not prevent every domestic violence gun homicide, and no, and we would never claim that. And also, we know, again, when you eliminate all other factors at play, it is domestic violence, sort of these surrender laws, that are having the most impact when it comes to overall a state's sort of domestic violence gun homicides.
True, but your argument would be bolstered by the fact if those 19 individuals who were murdered by guns, had protective orders that were violated.
Yeah.
So, can anyone answer that?
Well, Deb, why don't you introduce yourself?
Deb DeBear, I'm the Executive Director of the Rhode Island Coalition Against Domestic Violence. John was not on our staff when we did this study, so that's why I'm jumping in. I didn't want him to be in the hot spot. There was not information for these deaths available to us to dig back that deep, and we didn't go into the court records to see prior situations. So we cannot answer that question, although I agree that it would be great to know if we could. So we relied on information from the media, and as the media reported about the homicides and the deaths. We're not able to go back retroactively in those 10 years and dig back all the historical data about each death.
Even to 2015? Wasn't it 2000? Was it 2009?
Yeah, this went for the past, starting back in 2006.
I'm sorry.
Yeah.
2006 to
2015. Yep. So
and you couldn't get it even from 2015?
Have some information from the more recent years, but we went back retroactively to look at a period of 10 years to look at what was really going on with all the homicides, what patterns were there, what trends were there. We didn't have any expectations about what we would find when we started. And so we're...
Okay, any further questions for Sarah? Representative Roberts.
Can you hear me? Okay. Did you say you worked for, I'm sorry, I'm hard of hearing, Everytown or for Bloomberg? Or is it one and the same? That's what I'm trying to clarify here.
I work for Everytown for gun safety. Yep.
Okay, so, and this was founded by the Bloomberg Group?
It was an organization that started out under Mayor Bloomberg's administration when he was in City Hall in New York City.
Okay, so may I ask, does he still fund both groups?
He is absolutely one of our funders, among hundreds and hundreds of other funders from across the country.
Okay. Okay, because I'm thinking, I've heard a lot this week in testimony and sitting here listening to you. I think it needs to be said that instead of attacking the mindless gun, we need to address the criminally minded person and make them have more tougher laws for these criminals to spend more time, in jail if they're going to attack people and assault them and kill them and all of this. I mean, this is off the topic for just a second, but I know a couple days ago we had a debate on the House floor about sexual offenders and where they should be placed in communities. Rather than arguing about that in the same way, maybe we need to have tougher laws for these criminals. And the same thing here with these gun laws. That's what I think. Instead of having tougher gun laws and infringing on the Second Amendment rights of people, we need to have stricter laws and penalties for the criminals. And that's just my thought. Thank you.
Yeah. No. And I would, again, I think just say that folks that work on this issue think this is a key way of preventing future violence. And I would just say that I know there's going to be some continued debate about how far you want this to go. If you decide on a state prohibitor, how much you want it to go beyond federal law or line up with federal law. Again, 75% of these particular protective orders, folks were already prohibited by federal law. So essentially, again, they are already prohibited from possessing firearms. And this is just sort of making sure that there is some kind of protocol in place by which sort of we make sure they comply with that prohibitor by turning in their firearms.
Okay, I think that many of us are aware, maybe not everybody, but many of us are aware that this seems to be like a tactic just to assault the Second Amendment rights used by Bloomberg. If it weren't this way, maybe it would be some other way. But that's what this is. It's an assault on the Second Amendment rights. And that's all I have to say. Thank you.
Okay.
Any further questions? Yes, Representative Knight.
I just wanted to take a moment to point out, it comes up a lot in our testimony, this federal law piece, and I think that everyone would do well to remember that the federal law, as far as Rhode Island is concerned, it's almost a dead letter. Yes, it's illegal for people convicted of domestic violence misdemeanor under federal law to possess a firearm, but there is no federal enforcement mechanism in our state. There's no federal cops running around investigating domestic violence cases and busting people. The warning on the no contact order, the district court no contact order that Mr. Sicoccio pointed out before is simply that. It's a warning. It's not even worth the ink that's on the paper because there's no enforcement behind it. This bill that we're debating, if it were to go into effect, would mimic the requirements of that law, but it would have an important added element of there's 39 and change police departments to enforce it. And I just wanted to throw that out there because I think we get lost with that federal rule. Thank you.
Any Representative Price?
Thanks, Chairman. What does your organization, what's their thoughts on the relinquishing your weapons to a friend rather than the state police or the firearms dealer? Is there any cases where there's even if you want to go outside of Rhode Island, has there been cases that, well, no, let's stick in Rhode Island because this is a Rhode Island issue, but what's the any cases that someone has gotten their firearm from a friend that they've relinquished it to?
Yeah. Well, in terms of our organization position, we don't recommend it, and we don't think it's a best practice. And we also realize, though, there are states, and we work with a lot of these states that we think have great state laws, that third-party relinquishment is a piece of that. And in part, that is just for those states sort of the reality they were grappling with in terms of thinking through storage and things like that. At the same time, one of the reasons that we don't think it's a best practice is because we do have examples, at least we've spent more time working on this in other states than in Rhode Island, of where third-party surrender either continues to represent a threat to the victim, or in some of the worst cases, an abuser has been able to get access to those firearms again and used it to harm a victim.
But nothing in Rhode Island?
That's not something that we've looked into, no.
Okay, I just, sometimes I wonder if we're addressing something that's really a non-issue as far as the relinquishment part of it.
I think it's an issue. I think it's an issue, which is why we don't think it's the best practice. But again, I think states then, if they do decide to do it, come up with some pretty protocols around that end too, to make sure if you're going to do it, that the person who's storing the firearms recognizes there are consequences if they allow the abuser to get access to those firearms, and you do your best sort of to make sure that it's sort of the safest, if it's going to be a option, that it's the safest option possible.
Right. So, but it's not a problem in Rhode Island, though, right? Is that?
We haven't looked into it, so I can't say. It's probably, and I would say too, again, part of it is it a problem maybe because, you actually see the end result, an injury or a death. And again, as we've said, firearm threats play a significant role in domestic violence. And I do think that for a number of individuals, it doesn't feel like a particularly safe option to think about a family member or someone that the abuser has pretty easy access to having those firearms.
Right, I could see them feeling that way, but hasn't been an issue, so that's why I just working through the bill and just addressing that part, so thank you.
Representative Knight.
It hasn't been an issue because, as our study shows, judges aren't ordering the takeaway of firearms. There's very few cases in our system right now where people are actually ordered to give up the firearm and transmit it to some other entity, including that friendly third party. It's the friendly third party thing is it's a loophole in our law these days. It's not a loophole in our law, but when we have it there, it is like a lot of elements of our existing gun law that we always call as the safest around. It is it's a bit of a mask because it's there in law. You can say that there's a requirement that we have to hand it off to a third party, but it's not easily enforced. It's easily violated. And you can just see in the heat of the moment if your relative or your best friend in the world has the guns and the guy comes over and says, give me my gun, I really want my gun, I really need it, it's important, in the middle of the night. You could see how someone could be pressured to give it up. So if we're going to have a turnover to third-party law, let's turn it over to a third party that we can trust to keep the gun even in times of stress, and that would be the police departments.
Again, I don't, just to correct the record, family members are not allowed. You're not allowed to turn over to family members. We've been saying that a lot.
Right, it's neutral third parties.
Friend, yes.
Yeah, right. But not family. I agree,
right,
yes.
Okay. Any further questions for Sarah? Sarah, I could not wrap my head around how a judge would ever allow someone to keep a gun when, when there's an allegation that he made me lie on the floor of his apartment and put a gun to my head, said he could put a bullet in my head and leave me there. And as I read your report, which I did read last year, I guess I just didn't pick up on this. The court did issue a protective order, and the protective order did prohibit the former boyfriend from possessing firearms under federal law. So the judge did order him not to possess firearms. That's correct, right? Okay.
That is correct.
And that's true also in the case of the woman who reported that he told me he was going back to his truck to get a gun to kill me. There, too, the judge did order that he not possess firearms. Is that correct?
And again, this gets back to a little bit of sort of why we feel so strongly about the relinquishment piece of the law. Again, the studies that we have looked at and the evidence keeps growing that it really is the surrender piece of it, for whatever reason, that is one of the biggest factors in terms of reducing domestic violence, injuries, and homicides. Again, the prohibitor, you hope it's enough, and it should be enough, but again, there's something about having that additional sort of set of protocols and practices that is making a difference in states across the country.
And so we've heard about the 13% number, which is where the judge ordered surrender, and there was some indication of violence and or guns in the situation, and 5% overall, which includes situations where there may not have been allegations about strong physical violence. But it's also, your report also shows that in 73% of cases, the judge, see, I've been for years thinking, because I've been to court, I'm not a criminal practitioner, but I've been on various things, and what I see is the judge is ordering people not to possess guns. So your report shows that 73% of the time, and that includes all situations, so maybe there was no gun alleged even to be involved, 73% of the time the judge did order that the person not possess guns. Okay.
That's correct.
All right. Now it's making a little more, now that makes me feel a little better about my experience and what I've seen. Okay. Any further questions? Oh, Sarah, have you seen Judge Fort's letter?
I have not, actually.
I
heard it for the
Representative
first time
Corvese
today.
will give you a copy, and then we'll go to Heather, who I'm sure has some wonderful information because she's in the courtroom all the time. And then we'll come back to you. I'm curious what your thoughts are on his letter.
Okay.
Heather? Sarah, did you have an opportunity to look at Judge Fort's letter?
Ed.
And do you have an opinion on that or any thoughts on that? Or
I think
does it stand on its own? Or
say about it is it could stand on its own for sure. And I would also say that when we've had the opportunity not just to work on legislation in other states, but also to do a lot of work on the ground once a piece of legislation is passed, we work very closely with judges, sheriffs, police, many of whom were either in opposition of a law like this or weren't certain it was necessary. And we've actually found that once the law is passed, really the sky doesn't fall, that folks that maybe weren't sure if it was a good idea or not sort of realized that it actually had very little impact on their day-to-day courtroom dealings, that it didn't add a whole lot of time to the process, and it actually the whole sort of introduction of the concept into the courtroom went a lot smoother than I thought it was going to. And really, again, what you can do, while you might be removing some aspects of discretion or judicial discretion, what we've been able to do, again, in the implementation work is work closely with judges in different jurisdictions to think through what makes the most sense within the parameters of the law, what protocols make the most sense for their courtrooms. And that's, again, I think been a useful way to kind of bridge when someone might feel some hesitancy or opposition to the law to sort of once they see the law put into practice, we often end up finding that judges end up being pretty supportive of the process in general.
Okay, thank you. Any further questions?